Welcome to this session on international organizations. My name is David Moore. I'm a professor here at BYU Law School. My area of expertise is foreign relations law. We have here today with us three distinguished panelists, each of whom will address us on this topic, and then we'll open up time for question and answer. Each of our panelists has a very impressive background that's detailed in their written biographies. I will just introduce them by their current position and then turn the time over to them. We'll hear first from Elizabeta Kitanovic, who is the Executive Secretary of the Conference of European Churches. She will be followed by Kishan Manocha, who is Senior Advisor on the Freedom of Religion and Belief, Senior Advisor on Freedom of Religion and Belief with the Organization for Security and Cooperation in Europe, Office for Democratic Institutions and Human Rights. Finally, we have Faith Delos Reyes, who is a research and project coordinator at the Human Rights Resource Center of the University of Indonesia. Grateful to each of you for coming, and we're excited to hear from you. We'll turn the time over to Elizabeta.
Thank you very much. I would first like to thank Call Durham for this invitation and to BYU University which is organizing this great symposium on law and religion, and also to my friends from Brussels who belongs to the Church Jesus Christ of Latter-day Saints, to Warren and Lydia Hansen, and also to say big thanks to the students who are doing marvelous work in accompanying this conference. As it was previously said, I come from the Conference of European Churches, and I will just briefly introduce the organization. The Conference of European Churches is a fellowship of some 114 Orthodox, Protestant, Anglican, and Old Catholic churches from all countries of Europe, plus 40 national council of churches and organizations in partnership. CAC was founded in 1959, and this organization was born in the time of the Cold War, where churches didn't accept division of the continent because they believed that in Jesus Christ there is no division. Churches have been preaching and practicing the concept of justice due to their own historical development. For CAC member churches, it was always clear that religious freedom or belief is the fundamental right of every person living on the earth, recognizing at the same time forum internum and forum externum within the religious freedom principle. This means that whether as an individual or in the community, this right is exercised and granted by international human rights law. Even if the legislative framework is very clear, the part of its implementation still remains. Human rights in general are the area where the churches have permanent work to do, whether to defend their own interest and to advocate for the rights of the others. I will say just something briefly how we as Conference of European Churches are engaged with European institutions and with international organizations like European Union, Council of Europe, OSCE, and UN on the European level. Concerning the EU, we have established very good links with European Commission. And for almost 2 decades, we have dialogue seminars, which also are now legally binding for European Commission, and they're based on Article 17 of Treaty of Lisbon, which invites churches for an open, transparent, and regular dialogue. These dialogues are relating to different sectoral policies like human rights, social affairs, bioethics, climate change and environment, intercultural, interreligious dialogue, etc. In terms of legislative framework, I will just remind that in the EU human rights system, we have EU Charter on Fundamental Rights, which became legally binding in 2009 with the adoption of the Lisbon Treaty. The Lisbon Treaty underlines that the inspiration for the European Union is driven from the cultural, religious, and humanist inheritance of Europe. In its Article 10, Treaty of Functioning of the European Union, it was stipulated that in defining and implementing its policies, the European Union will combat discrimination discrimination based on many different grounds, among them also religion or belief. In Article 13, respect for religious rights and cultural traditions were also underlined. Finally, the Article 17 invites churches, religious communities, philosophical and non-confessional organizations for an open, transparent and regular dialogue with European institutions. So, as I mentioned, twice per year, Conference of European Churches, together with its counterpart, COMECE, has dialogue seminars on different topics, but also we are invited very much by European Commission, together with other church representations and religious communities representation in Brussels, to contribute to the development of the EU policies and their institutional frameworks. I will just mention one recent event which took place on the 1st and 2nd October. That was annual colloquium on fundamental rights related to the topic of tolerance and respect, preventing and combating anti-Semitism and anti-Muslim hatred in Europe, where we have been invited to contribute to the development of these policies, which were basically one of the responses of European Commission after the attacks in Paris and Copenhagen, which took place in 2015. This was an important subject because the fear concerning security of European Jews has increased, as well as anti-Muslim hatred, which has included physical and verbal violence. This project was set up in order to look into deep roots in origins of anti-Semitic and anti-Muslim incidents in the European Union, which do have an impact on growing fear in European society. This consultation discussed the questions such as, what is the role and responsibility of society in combating anti-Muslim hatred and anti-Semitism? What are the legal mechanisms needed for the European Union to combat the hate crimes against different religious groups? How can the EU assure the legal framework for helping victims and combat racism and xenophobia? What are the roles of the schools relating to human rights education, citizenship training, Holocaust remembrance? So there is basically several ways how Conference of European Churches as an NGO communicate with the EU institutions. For example, these were two examples where we participate. One, for example, is dialogue seminar. Another is consultations, like you just mentioned, where we are invited to give also our contribution from the ethical and Christian point of view. But this is the communication related from European institutions to the churches, to Conference of European Churches, to NGO organizations, then from NGO organization to the European institutions, such as European Commission in this case, but also, for example, as Conference of European Churches, we also have communication with our member churches, and our member churches also have communication vis-a-vis Conference of European Churches, what means that we take all these different communications which are related to one another in order to create good and stable human rights policies which can contribute to the international organizations in order to provide the legal and safe framework for religious freedom to exist. As Conference of European Churches, we are working also on human rights vis-a-vis our members. And in this capacity, we have set up a summer school on human rights, which was based on the Human Rights Training Manual for European Churches that we issued in 2012. First, we started with freedom of religion or belief. Then this year we had a school which related to anti-discrimination, where we have touched upon the questions on anti-Semitism and Islamophobia. In 2016, we are going to touch upon the questions of children's and women's rights. What we are saying is basically that we, in terms of our advocacy vis-a-vis European institutions, we are asking European Commission and other international organizations to do certain work on promotion and protection of freedom of religion and belief, but we also, as churches, we also have demands vis-a-vis our members, and we always encourage churches to speak up when in the public sphere when violation of freedom of religion or belief occurs. So recently, we have organized one conference in Halki in Turkey. This was the school which was closed by Turkish authorities in 1971. And we advocated that European Commission should also work and together with the EU Fundamental Rights Agency produce report on the state of fundamental rights inside of the European Union, because we have seen that in the European Union, External Action Service has its tools tool, which is called Guidelines on Freedom of Religion or Belief, which was mentioned several times, and we have been advocated for it for several years, together with the NGO, with other NGOs and civil society organizations, as well with other church and religious communities in Brussels, because we think that it's important that European Union not only do and report on freedom of religion or belief outside of the European Union, but also to look what is going on inside of the European Union. And in Britain, in UK, in France, in Denmark, in other European countries, because we cannot pretend that freedom of religion or belief is protected also in the old member states, because there are many legal challenges which exist, but also in everyday life we have seen how much there is rise of anti-Semitic incidents and also anti-Muslim hatred in the society. But also, last but not least, we should not forget that also minority churches also face with violation of religious freedom also in the countries of the European Union. When we come to other institutions of the European Union, we need to say that as CAC we have established cooperation with European Parliament's Intergroup on Freedom of Religion or Belief and Religious Tolerance. So, for example, if we have a CAC member church which is facing with violation of religious freedom and has problem with the law related to this issue, our task is to establish and to report to also this intergroup violation of religious freedom. So this EP working group on freedom of religion or belief and religious tolerance has also its annual report, and we try to contribute also to this report with the different information that we gather from the grassroots level from 40 European countries. I have mentioned already the EU Fundamental Rights Agency, and this EU Fundamental Rights Agency has already produced several reports on anti-Semitism and Islamophobia, but where we are advocating also is that there should be also one report which relates to violation of freedom of religion or belief on all grounds, also taking minority churches which do face with violations in the countries of the European Union that I have mentioned. I need to say that the EU Fundamental Rights Agency has Fundamental Rights Platform where we are members, and this is a platform which has over 400 NGOs, and they organize every 2 years meetings where this violation of human rights can be reported and discussed in the broader manner. This platform is very useful because it is possible to find also very good partners, but also to feed the EU Fundamental Rights Agency with information about violation of about human rights inside of the EU countries. Then I need to say that I mentioned already that the External Action Service has guidelines on freedom of religion or belief. These guidelines were issued in 2013. After 3 years, there is going to be a review of these guidelines, and we are in the process of drafting letters to MEPs to raise questions on the implementation of these guidelines. For example, how much financial assistance was put into the force related to promotion or protection of freedom of religion or belief outside of the European countries. Is there any list of the country priorities which was set up by the External Action Service, etc. And then concerning the Council of the European Union, there is a special task force on human rights and intercultural dialogue, and through the Human Rights and Democracy Network, where we are members, we are receiving update information of what is on the agenda of the EU member states related to the violation of human rights, in particular on freedom of religion or belief. When we come to the Council of Europe, this is another international organization which has 47 member states as their members. We need to say that CAC is also a member of the NGO platform, and we are very much invited to contribute to the project on interreligious dimension of intercultural dialogue based on the Council of Europe white paper on intercultural and interreligious dialogue. So we are also very active in the Council of Europe. When we come to United Nations, we have close links with the Office of Special Rapporteur on Freedom of Religion or Belief with Mr. Heine Bielefeld. And if he's doing certain visits to certain countries, we also try to feed with information that we gather from our members related to violation of human rights and in particular on freedom of religion or belief. Last but not least, we are also active in the OSCE, international organization, and especially we are participating in different roundtables which relate to violation of human rights and in particular in freedom of religion or belief. And my colleague is going probably to mention that there is next roundtable which is going to take place in Odessa, and currently we are going to prepare basically our input on this issue, which is going to come up on the 3rd of November. So this all great work wouldn't be possible to be done without our members. Our CAC member churches, so we have 114 from 40 European countries, are very much engaged and very much interested in freedom of religion or belief, which is in DNA of our organizations. And so with active membership, it is possible to achieve certain impact, like we had, for example, in the drafting process on guidelines on freedom of religion or belief, which we believe that it has certain impact on the promotion and protection of this fundamental right within the European Union. Thank you very much for your attention.
Good morning, everyone, and it's good to be back. I was here last year wearing a different hat, not literally, but metaphorically, and I'm grateful to Cole Durham and the organisers of this great symposium for this second invitation, and to just present, I guess, with the time that we have, an overview, really a brief overview of the approach, the work that the OSCE, the Organization of Security and Cooperation in Europe, does in the field of freedom of religion or belief. Now, I should caveat this by saying I've only been with the OSCE since May, so I'm very new. I may also say things that are my own personal reflections and opinions and veer from the party line, so to speak. So I know this is being videoed and taped, but forgive me, or forgive the OSCE if I go beyond my brief. But also, it won't be possible to present a full context, if you like, the geopolitical, the social, the institutional, all those factors that shape the approach to a very complicated human rights concern. So if the organizers are here and listening, I'll be happy to come back next year and to continue the discussion. What I would like to do in the brief time available is just to say some words about the framework within which the OSCE conducts its work on FORB, what is the understanding of FORB within this framework, some of the principles and characteristics of the approach that OSCE takes, and if we have time to evaluate some of the strengths and limitations of this approach. Now, I should also say that when I refer to the OSCE, one hand refer to it as the totality of its participating states, but I'll distinguish that from when I talk about the OSCE institution, which on behalf of the participating states takes forward the activities to promote and protect FORB, which is the Office for Democratic Institutions and Human Rights, ODIHR. So I will try to make that distinction clear, because ODIHR, the office I work in, is set up to assist participating states to advance FORB. And ODIHR sticks as closely as it can to its mandate, which stems from the commitments, which are not legally binding. They're aspirations, but they're grounded within international human rights law. So ODIHR takes forward its work to assist states to live up to these commitments. The states themselves who've entered into these commitments voluntarily, no one coerced them, sometimes diverge from what they have agreed to, but that's nothing new. So I just want to point that out. That's a constant challenge. So the first question really is, what on earth is an organization set up during the Cold War when security issues, the agenda was very different from what it is today? Why does it get involved in the field of freedom of original belief? Well, OSCE has a very comprehensive concept of security. This was set out in its founding document, the Helsinki Final Act of 1975. It views security in comprising three principal dimensions: the military, political, fine, the economic, environmental, the second dimension, and then this third dimension, the human dimension, which is about human rights and fundamental freedoms, about democracy and the rule of law. So on the one hand, you could argue, well, yes, it is a security organization. It comprises 57 participating states stretching from North America, US, Canada, right through to and including Mongolia. So a huge section of the Northern Hemisphere, security organization in that sense, but actually also because from the very outset, human rights and fundamental freedoms were set out clearly within the human dimension commitments, it could be referred to equally as a human rights organization. So this definition, this understanding of security is very broad, it's very wide, it's very deep, and within that sits freedom of conscience, thought, religion or belief, as stated in 1975. And the Helsinki Final Act said, the participating states will respect human rights and fundamental freedoms, including the freedom of thought, conscience, religion or belief, for all, without distinction as to race, sex, language, or religion. And the participating states recognize the universal significance of human rights and fundamental freedoms, respect for which is an essential factor for the peace, justice, and well-being necessary to ensure the development of friendly relations and cooperation among themselves as among all states. So, concern for FORB as a fundamental right available to all is something woven into the very fabric of the organization and has been elaborated on over the years to become one of the more developed set of standards in this area. So there is this, what we call normative acquis. It's not law, you could call it soft law, but it has an influence. And stemming from that is this practical understanding, this practical acquis, this practical set of measures that follow. And this, I think the important point in all of this, and the most recent commitment, the Ministerial Council decision of 2013, agreed in Kiev, reaffirms the explicit link, structural link between FORB and security. So what we take from this within the OSCE and within ODIHR is not just that freedom of original belief is a nice-to-have human right, but actually has strategic value, that actually it is the foundation of security. When states talk about security and concerns for security and concerns around security, and clearly there are many issues prevalent in the region which are a great threat, and those issues have developed over the years and new threats have emerged. The point that is made time and time again by OSCE institutions is that actually your greatest investment in security should be investing in freedom of original belief, and in addition to other human rights. They're interrelated. There's no compartmentalization here. So it's not just a human right. Of course it is. It has strategic value. And I think that is something which policymakers increasingly get. They don't get the language of human rights, or they're resistant to the language of human rights, which is very sad and surprising given they've spelt these things out over the years and agreed to these things over the years. Then they do get the argument, well, it has value for the protection of our society and our place in the world. And this builds on some of the comments, number of comments made already in this event. Now, the wider context, of course, in relation to FORB is that it is taking on, I wouldn't say new meaning, but it's certainly its scope is expanding as a result of a number of processes that have been sweeping through, if you like, the OSCE region, which is no different from the wider EU or Council of Europe or Northern Hemisphere. It's, same countries. Are two very interesting processes, which have been, again, alluded to, touched on in this conference. One is the increasing publicization of religion. Religion has a more public profile today, and pluralization, diversity of religions or beliefs within the region, but also within the same states within the region. So there's not it's more present and more visible. There's more of it within the same country. And FORB is becoming more present in new ways in the life of society. It's taking on new forms. It's has implications for education, for prisoners in prisons, migrants, refugees, all these issues, employment, of course. So we're dealing with something that is evolving, that is changing, that is clearly looking different from what it did 40 years ago. And that's something which the OSCE participating states bear in mind, something which the OSCE institutions like ODIHR have to bear in mind as they look at practical measures to assist states to live up to their commitments. Now, when we look at the commitments, what do they say about FORB? How is it understood? This is, of course, the ideal. This is the aspiration. But because it's the ideal and aspiration, it's been written down, it's been clearly stated, OSCE institutions like ODIHR are mandated to make this message time and time again. And the message is FORB is to be understood in, if you like, dynamic, thick, comprehensive terms. It is not to be given to communities of religion or belief that the state recognizes as a concession to them on condition that they do certain things. It is inherent. It is based on their self-understanding. It is grounded in universality, freedom, and equality, and that has many implications. It's something which protects the politically weak as well as strong, the dominant majority and also the minority communities, so to speak. But it is not just a right to be advanced on its own, it's interrelated with a whole range of other rights: assembly, opinion, expression, the right to be free from torture, the right to life. They are to be advanced together if the human security agenda is to have any meaning in the world today. And yes, they are to be advanced within the contexts of the participating states. We have to conceptualize FORB, not idealize it, yes, but not turn it into an ideology, because that is equally unhelpful. We have to be sensitive to reality. But that sensitivity doesn't mean to say that we endorse variations that are abdications of the state's fundamental duties. And this leads me to the final point I'll make, because time is running out, that there has been this discussion within the OSCE. You may be familiar with it. Some states saying, well, it's about human rights. Other states saying, well, it's more, yes, but we need to really focus on promoting tolerance and mutual understanding and dialogue and leave it to the communities to sort it out. OSCE institutions have made it very clear, most recently in the Supplementary Human Dimension meeting in July this year on FORB, the first meeting on FORB for 5 years. That's quite telling. But the point that was made time and time again is, while no one disputes the need for dialogue, for communities to come together, to work together, to advance religious freedom together, and those measures need to be more systematically explored, it can never substitute for the inescapable duty on states to protect, to respect, and to promote or facilitate FORB. That is their duty. It is incumbent on them. And within that facilitation, that promotion, they should do everything in their power to encourage dialogue, not to interfere in that process, to let civil society to go ahead and develop that process, but ensure that human rights for all are guaranteed. Otherwise, those dialogues, those processes are meaningless. They're not going to address reality. But to be very, very clear that to just abdicate responsibility, to delegate it to religious or belief communities, to get on with it, is not enough. The human rights approach has to be given the highest emphasis, because otherwise what we find is states standing behind wonderful gatherings that promotes tolerance and understanding and actually continuing to violate the human rights and particularly the freedom of religion and belief of their citizens and others. That's a message that ODIHR has been putting across, will carry on putting across. Unfortunately, time does not permit a further discussion, but maybe those points will come out in the ensuing question and answer session. So thank you for your attention.
Hi, good morning. Thank you for coming to our session. I'm Faith. I'm from the Human Rights Resource Center, and I'm here to give you a very selective and what David hopes will be a very brief overview of our research entitled Keeping the Faith, a Study of Freedom of Thought, Conscience, and Religion in ASEAN. Okay, so ASEAN is comprised of 10 member states. We have Laos, PDR, Myanmar, Thailand, Singapore, Malaysia, Vietnam, Cambodia, Indonesia, Brunei, and the Philippines. Very broadly speaking, in terms of religion, it's very diverse. But speaking very broadly again, to the southern part of the region is mostly dominated by Islam, with the exception of Singapore and eastern parts, some eastern parts of Malaysia. This region was previously known as the Malay Archipelago. To the northern part, this part of the region is dominated by Buddhism, Taoism, and what is known as Chinese religions or traditional religions. Although I should point out that with regard to Vietnam, mostly people are irreligious. So 70% of the population do not identify with any religion. To the east, we have the Philippines, which is largely Christian. So 90% of the Philippines is comprised of Christians, mostly Roman Catholic. And the rationale for this book is that in 2012, the heads of state of the ASEAN member states signed the ASEAN Human Rights Declaration, uniformly affirming and committing to respect, promote, and protect human rights. And it also mentioned specifically that every person has the right to freedom of thought, conscience, and religion, and that all forms of intolerance, discrimination, and incitement of hatred based on religion and beliefs shall be eliminated. So we thought that this is a very commendable political aspiration, and so we came up with this book, and it's comprised of 10 country reports, and each country report covers legislative and policy framework, the trends in freedom of thought, conscience, and religion. So we look at prevalence of discrimination, persecution, how states react when these things happen, and how it affects bordering countries. And then we also look at contributing factors. And then with these country reports, our team leader collated and produced a synthesis report highlighting the general trends in the region. So moving on to some of our findings. In terms of international instruments, as we know, many of the substantive norms when it comes to freedom of religion and belief stems from the International Covenant on Civil and Political Rights. Now, if you look at the chart that we have on the screen, so the BRN, just reading the headings in the column, so that's Brunei Darussalam, KHM is Cambodia, Indonesia, Laos, PDR, Malaysia, Myanmar, Philippines, Singapore, Thailand, and Vietnam. So with regard to the International Covenant on Civil and Political Rights, only 6 countries have signed this. And even with the 6, one, Laos, PDR, made a reservation saying that with regard to Article 18, which is the provision on freedom of religion and belief, Laos, PDR said that, let me see. How does it work? Laos PDR said that anyway, what it said was that with regard to Article 18, this is going to be observed as long as it does not cause disharmony among its different societies. So if your acts causes disunity or disharmony, then they will consider that Article 18 is not to be applicable. You also have other instruments that have provisions that relate to freedom of religion and belief. And as you can see from the chart, ASEAN countries are mostly hesitant or reluctant when it comes to signing on to international conventions. The only instruments that the ASEAN countries universally signed are the CRC and the CEDAW, the one on women and the one on children. But even then, with regard to the Convention on the Rights of the Child, 3 countries made reservation, and these are Malaysia. Malaysia made a reservation with respect to Article 14, which guarantees the right of the child to freedom of religion and belief. Brunei made a reservation to the provisions that are contrary to the principles of Islam, and Singapore said that it makes reservations to provisions that are contrary to the religions and values of its many religions and races. So similarly with the CEDAW, reservations were also made on the basis that we can say of religion by also of these 3 countries, by Singapore, Malaysia, and Brunei. Moving on, we also looked at the constitution of the countries, of the 10 countries, and we found out that religious freedom is a very important commitment for ASEAN member states. It is legally guaranteed in all constitutions except for Brunei Darussalam. So if you look at the wordings, all other countries would describe freedom of religion as a right, something that they guarantee. But if you look at Brunei Darussalam, it merely says that the official religion of Brunei Darussalam shall be Islamic religion. All other religions may be practiced in peace and harmony with Islam. And when they talk about Islam, it's a very specific sect, which is the Sunni Shafi'ite sect of Islam. And this constitutional provision is really expressed in policy and in practice in Brunei, because when it attained independence in the early 1980s, the Sultan said that Brunei shall be forever Melayu Islam Beraja, which means that they are Malay Islamic monarchy. So ever since then, they have rejected legal pluralism, liberalism, and freedom of religion. With regard to declared state-religion relationship, 5 out of 10 countries have constitutions that expressly or implicitly privilege the majority religion, or that privilege one religion as the religion of the majority. So these are Brunei, Cambodia, Malaysia, Thailand, and Myanmar, so the ones on this side. So the constitutions of Brunei, Cambodia, and Malaysia contain clauses outrightly declaring a state religion. So for Brunei, it's Islam. For Cambodia, it's Buddhism. And for Malaysia, it's Islam also. Thailand and Myanmar privilege religion, which is Buddhism, in their constitutions, but stop short of declaring them a state religion. With regard to Indonesia, what it says is that the state shall be based upon the belief in the one and only God. So while the constitution does not expressly refer to a religion, it nonetheless privileges monotheistic belief. And also perhaps later Pak Agus will also say that aside from that, Indonesia actually recognizes only 6 religions. With regard to Laos, PDR, Singapore, and Vietnam, they don't make any reference to religion. They leave open to the possibility that the state may control or privilege one religion or another. But generally, Singapore practices secularism. And what we observe in practice is that for Vietnam and Laos PDR, they allow you to practice so long as you don't go against their national interests. Like that, you don't touch national unity. You don't go against you don't create disunity, and you don't go against a social order. So the Philippines is the unique country in ASEAN, and it expressly states that the separation of church and state shall be inviolable. Because this is a symposium on social stability, I will highlight very quickly some countries that are facing social conflict based on religion. So first is Malaysia, where minorities or dissenters within Islam are facing some forms of persecution. So apostates who want to convert out of Islam are detained for rehabilitation. And then non-Orthodox or non-Sunni Muslims are also prosecuted for deviant teachings. So if you go against the Sunni teachings, which is the religion of the majority, then you can go to jail, you can be arrested for deviant teachings. And also there has been persecution of Shia Muslims, or harassments intentions are being committed against them. With regard to non-Muslim religious minorities, there has been symbolic violence. So there has been demolitions of places of worship and restrictions of worship. So within the last 10 years, around 6 churches were demolished, and around 12 Indian Hindu temples were also demolished. And among these Hindu temples is a 1,200-year-old Kandi or tomb. And they said that the basis for this demolition is that they don't have a permit. But if you look at it, when was the Malaysian state? When did Malaysia become a state? If you talk about a 1,000-year-old Kandi, then they predate the Malaysian state. So who would they get the permit from? And then also within the last years, I'm sure you've all heard of this controversy over the Allah case, where a court said that because traditionally in Malaysia, when they speak in Bahasa, they will refer to God as Allah, even if they're Christians. And there was a case where the court said that, okay, you can use the word Allah in your publication. And then this gave rise to a lot of destructions of churches, of Sikh temples, and also of Muslim mosques, but mostly the target was the Christian churches. With regard to Myanmar, there was a significant increase of violence since 2012 when they moved towards democratization. So the most extensively documented is the one of the Rohingya Muslims in the northern Rakhine state, where they suffer lack of the right to citizenship, restrictions on freedom of movement, obstacles to family development, confiscations of land, forced labor, arbitrary taxation, and exclusion from the local economy. So from 2012 to 2013, there were a lot of news reports about riots being committed in Myanmar. And as we can see on the chart, the causes for these riots are varied. So the first one, there was a rape of Tida Tue, who was a Buddhist. She was raped by Muslims, and this just gave rise to riots with people. When the news spread out, then people just started burning houses and attacking other people. So the total casualties are around 245. This includes both Muslims and Buddhists. And then we also highlight Indonesia, where after the Reformasi in 1998, there was an increase of communal violence between the Muslims and Christians. But this was okay. But in 2003 and 2004, peace agreements were entered into, and this abated the violence. But afterwards, we still see sporadic sporadic violence committed against the Ahmadiyya Muslims. So there's a fatwa or a directive that says that Ahmadiyyas are outside Islam, and it calls for the ban of the Ahmadiyyas, and there were attacks on mosques and other properties of the Ahmadiyyas. Also, with regard to the Shia Muslims, there were increased calls for them to be banned also, and there were violent attacks being committed against followers of Shia Muslims. And then other groups to a lesser extent that face religious persecution would include Muslim groups that are outside the majority Islam sect, and then the Aliran, Kepercayaan, and also the Christians. Now, what we have to understand with Indonesia is that different provinces have different religious majorities. So for instance, in one province, it might be the Muslims who are persecuted, while in another province, it might be the Christians. So it doesn't mean that all over the country, the Christians are being persecuted or the Ahmadiyyas are being persecuted. Okay, and then lastly, we highlight Brunei because in our study, what we noted was that among all the 10 ASEAN countries, it was Singapore and Brunei that did not have incidences of persecution. But with Brunei, it's kind of worrying because this signals that there's a general lack of political and civic space for dissent instead of people actually getting along. But it was really a sign of suppression. And also, we highlight Brunei because of the Sharia penal code, the challenge that it will bring, because it will be applicable to both Muslims and non-Muslims. So right now, they are in phase 1, which carries penalties that are comprised of fines and imprisonment. But when they roll out phase 2, that will include cutting off of limbs and I think whipping, caning. And then when they move to phase 3, then you'll have death by stoning. So for instance, for blasphemy, which applies to both Muslims and non-Muslims who are found to have insulted the Prophet, they could be sentenced to death or to a maximum of 30 years of imprisonment and 40 strokes if they do not repent. So, and also apostasy will be outlawed and punishable by death by stoning. And then sexual conduct such as extramarital sex, homosexual intercourse, and sexual intercourse against the order of nature is criminalized and punishable by death by stoning. So I'll just enumerate because I know I'm out of time. So factors influencing persecution and/or discrimination. So for the ASEAN region, what we thought really affects freedom of religion and persecution of minorities. We really emphasize politicization of religion, and then ethno-religious nationalism, and also weak rule of law. Thank you very much, David.
Sorry to be such a hard taskmaster, but this will leave us time for questions. So we'll open up now for questions from our panelists. There's a microphone that will go to the questioner, and we'll bring another one down to the panelists. If you'd stand and tell us your name and country.
My name is Fred Axelgard. I'm on the faculty at Brigham Young University at the Wheatley Institution. For Kishan, I appreciated your distinction you drew between establishing freedom of belief in religion as a human right as opposed to the dialogue. But I would just observe that, in fact, the connection between freedom of belief and security does depend on the existence of dialogue. And I'd just be interested if you could, I think your emphasis was on freedom belief as a human right. Could you just dilate a little bit on the importance of and how the OSCE contributes to the dialogue in this area? Thank you.
You can do either, whatever you feel.
Well, thank you, Fred. No, obviously these two processes they're not mutually exclusive. FORB has many dimensions. This is recognized within the OSCE. Human rights approaches are primary, very important, but that's not to play down the importance also of educational processes and the increasing importance of the need for states to facilitate, to encourage dialogue and partnerships. It's beyond simply just the question of getting together and talking, whether it be formally or informally, but actually building very stable, sustained, meaningful partnerships involving the state authorities, but also particularly civil society, and within that, religious belief communities, to advance the freedom of religion and belief for all, even if those communities are numerically small or obscure. It's to bear in mind that this is a very wide and encompassing human right. So in recent years, and again, the way that it works within the OSCE, the principal institution within the human dimension, ODIHR, can only take a steer from the mandate given to it, which are the commitments that are entered into by participating states. Therefore, it doesn't have, to that extent, a wide autonomy to go in and to do work. It could potentially do it, but it is strengthened in its approach if it can refer to a commitment. So in Kiev in 2013, there was the beginning of an elaboration of what this dialogue partnership would look like. We're hoping something will emerge this year in Belgrade. And what we're beginning to see, in any case, are the development, particularly west of Vienna, if you like, but also now increasingly east of Vienna into the southeast, the Caucasus, and into Central Asia, of dialogues and partnerships which are bringing together increasingly civil society to focus on issues of religious freedom. But it's very important that they do that. And these are just not talking shops which play down the challenges and the very real critical challenges facing and being faced today by numerically smaller groups and communities in societies where state control is pervasive, where, as we've been discussing these last couple of days, social stability is to be maintained by repressing those rising impulses brought about through the empowerment of religious and belief communities, who are playing a more increasingly visible role in their contribution towards secure societies, and that's seen as a threat. So the state begins to get very worried, very anxious, represses it, but then says, well, hold on, guys, we're bringing together representatives around these dialogue tables to look at the state of religion and belief in our society. But actually, when you go and look at them, you see that it's not a representative selection of communities that are engaging in the process. It's same old faces, the ones that the governments want to talk to and hear from. So that has to be addressed, and ODIHR is doing what it can to address it. One of the, I think, advantages or strengths that the OSCE has is that it's not just an intergovernmental organization that speaks to participating states, that speaks to governments. It has a direct line to civil society, and it has a direct line to religious and belief communities. And if that connection hasn't been as strong as it should be, that's a failing on the institution's part. That has to be strengthened, it has to be worked through, because that is the source, if you like, of the knowledge, the very important knowledge and information and intelligence on the ground about what are the real critical challenges that need to be addressed. Unless those voices are heard within these dialogues, then what's the point of having them? They're only going to be heard if the state also guarantees freedoms of opinion and expression and assembly. So it has to be conducted with a human rights law perspective, which is one of the strengths of what the EU is doing in terms of its dialogue. It's made that explicitly clear in, I think, Article 60-61 of the Lisbon Treaty, that dialogue is being conducted within human rights for all perspectives. So this is something which we're seeing emerge much more prominently now within the work of the EU, within the OSCE, and together with the call on states to respect, protect, promote, and facilitate. Hopefully we will see a shift in a positive direction, but one can only work at it.
I'm David Little. My question to both OSCE and ASEAN is in respect to the mechanisms that do or do not exist for holding member states to account. It seems to me in the case of ASEAN, the standards vary so much that it's going to be very unwieldy, so to speak, to hold members to account, and even the compliance with international instruments is so in variance that there's not much of a common standard to invoke. Is that right? And therefore I'm puzzled by how that might work out. OSCE seems to me more unified, am I right about this, in standards committed to? I understand it's not a legally binding organization, therefore I'm asking what are the informal or non-legal pressures or standards, mechanisms, let's say, that might be applied in holding each other to account?
Well, you guessed right already. For ASEAN, it's going to be very difficult because also, if you know, the ASEAN works on the basis of consensus. So if you don't agree, then they cannot force you to do it. But with regard to mechanisms, it does not exist. As you know, we have the ASEAN Intergovernmental Commission on Human Rights, but then even the ICHR is only a consultative body. It can only make suggestions or recommendations, and it cannot really hold a country to account. And even the ASEAN Human Rights Declaration, it's not a binding. Yeah. So what we hope is that as we move towards ASEAN integration, because in ASEAN right now it's a big deal that we're gonna become a one happy community in 2015, is that as we become closer, that there's gonna be pressure from the countries for the others to step up. For instance, for the issue of freedom of religion with regard to the Rohingya issue, it's being highlighted that what happens in Myanmar does not only stay in Myanmar, it affects Thailand, it affects Malaysia, it affects Indonesia. So there has been some kind of soft ASEAN pressure from Myanmar to do something about it. So as we move towards integration, hopefully this will get people to pressure each other more.
Thank you for the question. Well, the OSCE traditionally does not take an approach to naming and shaming. Now, that's not to say that at meetings convened by the OSCE that goes on, because there's constantly telling each other what's not working and blaming and the rest of it. But the approach then that the institutions of the OSCE have taken is to create those spaces, principally human dimension implementation meetings and supplementary human dimension meetings and human dimension seminars and other in-country, within participating state roundtables and meetings, where the gap between aspiration and reality, between commitment and implementation, becomes very clear. One of the strengths of working across the board with government, civil society, etc., is to bring those voices into those spaces, particularly outside those countries where you can't be heard in some places, let's be honest, where your livelihoods are threatened, to speak truth to power. There are constraints, resources, time, many practical challenges. But for those who've been able to make those journeys, and there are funds available for that, there is support available for that, it is an empowering step in this very lonely struggle to have your voice heard when all you face in your home state is censorship, media disinformation, and the like. So that is an empowering step. There are others. They're being looked at. Information is regularly provided, monitoring, and that capacity within the organization is being looked at, look to strengthen it. But beyond that, there are no tools. There's no sanctions. There's nothing to enforce commitment. But we hope it complements those tools that are being deployed by other intergovernmental and other international organizations, so that the OSCE's initiatives add value. But we have to work harder to make sure that those spaces actually address those issues and those voices can be heard.
Is there any concern to move in that direction of specific mechanisms which might put pressure on delinquent governments within the four aspects, I mean, or you just trust that other aspects of the interconnections will apply those pressures?
Could you
Sorry.
repeat that statement just so we get it on the mic?
Sorry, yes. Well, the likelihood of developing any tools which have force, which bite, is highly unlikely. And states, some states, I should say, be careful what I go on the record here and say, are very averse to any more intrusive scrutiny from supranational organizations. The real work is to build the infrastructure, preventive infrastructure within states to, if you like, look with states who are willing at a roadmap. You're here today, we can get you further along the road because this is in your political self-interest. This has strategic value. This takes a number of steps. The first could be awareness raising, capacity building, nice, gentle stuff. We won't veer into areas you don't want to get into, but we're also going to have conversations, because we're free to do so with civil society. Strengthen your advocacy, strengthen your ability to speak truth to power in those spaces open to you, and slowly construct something. Look at the mechanisms, the oversight, the scrutiny, strengthening national human rights institutions, ombuds offices, law enforcement, all those who have within their discretion the power to impact the lives of countless thousands, because you can have legislation that sounds pretty good, but officials who are actually blind to how to apply it in ways that are fair and just. So it's developing that. Those mechanisms require attention, and hopefully we'll find that actually that has significant value over time. But it requires effort, it requires funds to do it, and resources to make it possible. So.
I think we're out of time. Thank you for your participation. Please join me in thanking our panelists.